Good day, everyone. I am Angel Bandibas from PCBet 01402A, and the topic that I will discuss for today will be all about form of contract of partnership and the purpose of registration. Form of contract of partnership. A form of contract is a manner in which a contract is manifested or executed. General rule. As a general rule, no special form is required for the validity or existence of the contract of a partnership. It is according to Article 1356. So, for us to have an idea kung ano nga ba ang sasabi ng Article 1356, titingnan muna natin kung ano nga ba. Article 1356 states that a contract shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. So for now, magfo-focus muna tayo sa first sentence or sa first statement. Going back, yun nga sinabi, no special form is required for the validity or existence of the contract. The contract can be made orally or in written, regardless of the value of the contributions. An oral contract is a type of contract that is made through oral communication or spoken communication, whereas a written contract is a type of contract that is written. Word by word of the agreement should be written down. Tulad nga ng sinabi ko kanina or nang naka-state doon, a partnership doesn't need a special form. Any form will do as long as both of the parties or the partners knows about the type of form that is used. And anyways, the type of form used, whether orally or written, will not affect the validity or the existence of the partnership. But since a partnership should be registered sa SEC or sa Securities and Exchange Commission para makapag-operate ito legally, one of the requirements done is agreement should be written. Ang reason nito is to avoid misunderstanding and disputes among the partners. And for the formalization na rin, even though yung contract na made siya, nagawa siya through orally, yung agreement na ipapasa sa SEC should be in writing. Itong written agreement na ito yung tinatawag nating Articles of Co-Partnership. Yung mga information about sa partnership, such as the name of the partnership, the purpose, the rights and duties of the partners, etc. are stated there. Also, itong Articles of Co-Partnership, dapat hindi ito maging sekreto sa lahat ng members. Dapat lahat ng partners alam and aware sa kung ano yung mga nakasulat and nakastate sa Articles of Co-Partnership. If there is a general rule, there is an exception. Article 1771. A partnership may be constituted in any form except where immovable property or real rights are contributed thereto, in which case a public instrument shall be necessary. Ito na nga yung first exception natin. Where immovable property or real rights are contributed. Ano nga ba yung definition ng immovable property? An immovable property is a property that cannot be moved from one place to another. Example nga nito is a building and the land itself. So, next naman yung real rights. A real right is a right that is attached to a thing rather than a person. Example nito is ownership, pledge, and mortgage. Kung titingnan uli natin yung Article 1771, in-state nga dito na kapag ang partnership nag-contribute ng immovable property or ng real rights, a public instrument shall be necessary. Pero hindi in-state sa Article 1771 kung anong mangyayari if ang partnership hindi sila nag-provide ng public instrument or hindi nila ginawang public instrument yung immovable property or real rights na kinontribute nila. Dito na papasok yung Article 1773. Wherein ang sasabi dito na a contract of a partnership is void whenever immovable property is contributed thereto. If an inventory of said property is not made, signed by the parties, and attached to the public instrument. Article 1773 complements Article 1771. Kinumpleto na ito yung gustong sabihin ng Article 1771 kung saan, di ba sa Article 1771 sinabi lang na kailangan gawing public instrument. Pero dito, sinabi na kung ano yung consequence if hindi mo sinunod yung requirement na gawing public instrument. Automatically, sabi dito na kapag hindi mo na gawang public instrument yon, ang mga immovable property or real rights mo, automatically the contract of the partnership will be void. So, ano nga ba yung mga requirements para hindi maging void yung contract ng partnership? First, dapat merong public instrument. And the second, an inventory of the property contributed must be made, signed by the parties, and attached to the public instrument. So, babalik tayo sa public instrument, no? So, first, ano nga ba yung public instrument? A public instrument is any legal instrument or a legal document recorded with and authenticated by a public office or employee. A public document or instrument is one which is acknowledged before a notary public or any official authorized to administer oath by the person who executed the same. The party making the acknowledgement formally declares that the instrument is his free act and deed, while the officer taking the same attests and certifies that such party is known to him and that he is the same person who executed the instrument and acknowledged that the instrument is his free act and deed. So, ang public instrument, ang purpose nito is to inform the third person or the public na yung property na yun nag-i-exist and yung property na yun, yung immovable property na yun, mapapatunayan mo na sa'yo talaga yun siya or sa'yo talaga and i-contribute mo sa partnership. It is to let the public be aware na yung property mo na yun, gagamitin mo sa partnership or i-contribute mo sa partnership. Next, an inventory. Another requirement, diba, is an inventory. An inventory is very important in a partnership to show how much is due from each partner to complete his share in the common fund and how much is due to each of them in case of the liquidation. Again, review lang. Yung mga requirement para hindi ma-void yung contract ng partnership if a immovable property or real rights is contributed. First, there must be a public instrument and there must be an inventory. If no public instrument, no inventory, automatically the contract must be void. So next exemption to the general rule is when a partnership agreement is covered by Statute of Frauds. Agreements which fall within the scope of Statute of Frauds are not legally enforceable in court, although valid unless the same be in writing. In other words, if either party refused to comply with their agreement, the same could not be enforced. It is according to Article 1403 that is all about an enforceable contract. And under Section 2 is all about the scope of Statute of Fraud. So, and according sa general rule natin na to be enforceable, hindi naman kailangan na nakariten. It can be in any form. Pwedeng written, pwedeng oral. But if ang agreement nag-fall under Statute of Frauds, it must be in writing. Many situation or contracts that fall under Statute of Frauds, but for me, the best example is an agreement not to be performed within 1 year from the making thereof. So for example, on January 2020, si A and B nagkaroon ng oral contract that bubuo sila ng partnership after 1 year or let's say February 2021. The agreement should be in written, kung hindi, the contract will be unenforceable. Under the Statute of Frauds, the contract will be still unenforceable. So, unenforceable contract are those that cannot be reinforced or given effect in a court of law or sued upon by the reason of certain defects provided by law until and unless they are ratified according to law. Kasi nga, sa situation ni A and B, naka-state na after 1 year pa nila i-start yung partnership, then within that 1 year period, they cannot operate it. Hindi sila pwedeng mag-operate yung partnership na yun earlier since naka-state na yun sa contract and under the Statute of Frauds. So, itong exemption na to, it is a form of enforceability of a contract. While yung exemption naman kanina, which is all about immovable property or real rights, it is a form for validity of a contract. So, now, let's proceed to the next topic, which is the purpose of registration. Article 1772 states that every contract of a partnership having a capital of 3,000 pesos or more in money or property shall appear in a public instrument, which must be recorded in the Office of the Securities and Exchange Commission. Failure to comply with the requirements of the preceding paragraph shall not affect the liability of the partnership and the members thereof to third persons. So, for now naman, we will talk about the registration of a partnership. So, kanina, diba, tinalakay natin yung about sa real rights or sa immovable property. For now, we will talk about a personal property, which is a partnership with a capital of 3,000 pesos or more. So, yung mga requirements for this is, first, the contract must appear in a public instrument, just like katulad din kanina. And another one is it must be recorded or registered with the Securities and Exchange Commission. Pero, kung natatandaan nyo, yung sa Article 1772, in-state nito that failure to comply with the requirements of the preceding paragraph shall not affect the liability of the partnership and the members thereof to third person. So, pagdating dito, hindi ganoon ka-strict compared dun sa immovable property since it is a real rights. So, dito, ang tinataka lang naman natin is all about yung mga capital na 3,000 or more. Iyon lang yung nagre-require ng mga requirements na yan, like public instrument and pag-register. But, legally speaking, yung mga less than 3,000 or more, hindi sila required to appear, or their contract is not required to appear in a public instrument, and they are not that required to register, but it is recommended for their own convenience na rin as time goes by. So, yun. Next is, ano ba yung purpose ng registration? The requirement of a public instrument is imposed as a prerequisite to registration, and registration is necessary as a condition for the issuance of licenses to engage in a business or trade. The objective of the law is to make the recorded instrument open to all and give notice thereof to interested parties. So, bakit nga ba nagre-register? Siyempre, unang-una, for the legal purposes, para sa lisensya, and as a proof na kapag nagpa-register kayo, ibig sabihin, legal kayo and lawful yung partnership na yan. Also, the purpose of registration for public instrument, public document, is to announce that the property na pinapublic instrument mo is open to all, and to let the third person or the public or the interested parties aware that property exists and that property belongs to the partnership already. So, pinaka-purpose rin talaga ng registration is para ma-avoid ng mga partnership contract ang pagka-void, which is tama lang naman, di ba? Kapag na-void ang contract, automatically hindi ka na makakapag-operate, or kung pipilitin mo mang mag-operate, unlawful na kayo, which is wrong, right? I think that will be the end of my report. I hope may natutunan kayo, and for clarification, you can ask me. So, yan po. Thank you!